Hello everyone. Now we have Mr. Pranjal Prateek. He's a Senior Associate Competition and Antitrust team at Khaitan and Co. He's also a GNLU alumni. Nice to meet you, sir.
Same here.
So, sir, what does alternate dispute resolution mean to you?
See, as the name clearly suggests, it's an alternative forum to resolve your disputes, not going through the strict procedures that litigation takes you through, and as far as possible, amicably settling your disputes. That's how I will simply put it.
Okay. Knowing that you do work in the field of competition and antitrust, do you see any interface or interaction of ADR and competition law?
Generally, in terms of the kind of cases that we do, it is primarily, these are cases before the regulator where there are certain allegations of violations of a particular field of law and where the regulator can come in and perhaps check those sort of practices. So, strictly speaking, people won't see any direct interface between regulatory practice as such and ADR mechanism. Uh, However, we see in the cases that we handle, in complicated cases involving commercial issues, that parties tend to, have sort of parallel proceedings. So, in fact, in one of the recent cases that we handled, we saw that party had already invoked an arbitration, commercial arbitration. However, because the competition law in India, is not in derogation of any other law, and it's a law in addition to any law for the time being in force. So the party also invoked the jurisdiction of the Competition Act and challenged the practice of one of the parties that it is abusing its dominant position. So, though the essentially the problem was commercial, there was a case brought in for abusing dominant position, which sort of doesn't make sense and defeats the purpose of ADR mechanism.
So, which brings me to the question: do you think that since there's regulator and the consumers involved, the parties involved in competition law, do you think that pre-litigation mediation or out of court settlement should be made compulsory?
Well, I think this practice is in vogue at least for family issues. As far as I understand, in divorce cases, as far as I know, that there is compulsory mediation. However, I see some futility in that exercise to do that in all the cases, especially in regulatory cases, because regulatory cases are cases brought in for non-compliance with a regulatory regime. So, if you haven't complied, you simply have to face the music. I mean, there can't be an alternative way of settling it. So, ADR, in a way, to me, is also something to do with settling, something to do with mitigating, the coming out of the situation. So, I mean, there cannot be simply a settlement for having failed to, comply with the law. So, and for that matter, the Competition Act doesn't allow settlement procedures, at least in India. It's allowed somewhere else, but right now it's not in the focus in
And
India.
so finally, do you think that if once the parties do come to any sort of settlement, do you think it should be made binding, or it should be enforceable in the court of in the court of law?
Yes, I think that's important because it's a conscious move by the parties involved in the case to go and settle the case or to go and take the case to ADR and to reflect that seriousness, that conscious effort that must be made binding on the parties so that people honor this and ADR becomes effective.
Thank you so
Yeah,
much, sir. Thank you.
thank you.